Hello and welcome to ThePrint. The British era Penal Code and the Evidence Law, along with the somewhat younger Criminal Procedure Code, have all been overhauled. They've been rewritten. We have the three new criminal laws, which is the Bharatiya Nyaya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam. They've all come into effect on 1st of July. Now, a lot has been said and written and discussed on these three new criminal laws and changes that they bring in. In fact, we've done a few videos on it, and I'll be adding the links to those videos in the description of this video. But we haven't really discussed how these laws impact businesses and change corporate offenses. And for a country that talks a lot about ease of doing business, it's also important to see whether these three laws contribute to that ease or perpetuate unease. And to find out the answers to these questions, you have me, Apoorva Mandhani, and we have with us Sherbir Panag, who's the founder and managing partner of Panag Babu, which is the country's largest white-collar crimes and corporate governance law firm. Thank you so much for joining us, Sherbir.
Thank you, Apoorva. Thank you for having me.
Sherbir, just to start off right away, what was the need to bring in these laws? Was there a need, and what was the stated objective of bringing these in?
So, Apoorva, I think let's take a step back. We've had an extremely complex criminal justice system.
Right.
A criminal justice system that, and in all fairness, there's significant critique about criminal justice systems across the world. I don't think globally we've arrived at what's an ideal criminal justice system, and no one country can really take the pole position. So I want to put that caveat out there. And in that backdrop, ours had several challenges, both on the substantive law part, which is where the new laws come into place, as well as in the administration of justice, court infrastructure, number of judges, number of police personnel, number of prosecutors. And our criminal justice system has been in shambles, whichever way we slice it or dice it.
Right.
Our challenges are umpteen. With this background, do we need, if I have to rephrase your question, do we need an overhaul of our criminal justice system? Yes, absolutely we do. Does that big hole in our criminal justice system get filled with these three new laws? No, it doesn't. The stated objective, both if you sort of look at the structure, I think if you look at the political statements, a lot was made out about the need to do away with the colonial past.
Right.
And I think you also brought about the fact that these three laws found their genesis, in whichever way we cut it, in the British era. So there's a stated political purpose of creating a legal system that of having the laws deal and help with the decolonization process, and then there are other objectives of reorganization, reframing and recasting of offenses, helping procedure deal with and having offenses that deal with modern times, also having procedure that deal with procedure and evidentiary norms that deal with modern aspects, especially the bringing in of technology. I think if I take a step back, and I've taken 2 steps back now, keeping count. If I take a step back on the colonial premise,
Right.
I don't think that objective has really found itself, has been met.
Okay.
A significant portion, the substantive text of the new laws is heavily borrowed from the old laws. There's been a certain degree of reorganization. There are some new elements, but we are significantly still relying upon them. And I think the biggest missed opportunity of dealing with a colonial era law where we were subjects and not citizens was to enhance safeguards when it comes to liberty. Let us not forget that one of the most shameful statistics of our criminal justice system is the number of under trials that we have.
Right.
Which by ratio are almost are close to their 2/3 out of the total number of prisoners, approximately 2/3 are under trial versus 1/3 are actual convicts. This propensity for arrest without reasonable grounds, the fact that jurisprudence on saying that there should be reasonable grounds and principle-based guidance, this was a golden opportunity to really focus the substantive law on enhancing liberty, which we missed out on. There were several other procedural liberty-based safeguards that again are seen as part of which I see as missed opportunities. For example, the presence of legal counsel when questioning takes place. If any one of us has watched enough, sitcoms or US-based sitcoms, you always hear, the reading of the Miranda rights, and you have the right to remain silent, etc.,
Pleading the
etc.
fifth. Yeah.
Pleading the fifth, amongst all of those elements that are so germane to movies and sitcoms
Right.
in the US. And here we have a significant focus on custodial interrogation, a custodial interrogation period that's gotten enhanced. So that was a missed opportunity, and the lack of presence of legal counsel. I think the second missed opportunity was in terms of doing away with, though we're talking about the corporate side, but again, if the stated political objective was to have this decolonization of our criminal justice system, then why do we still retain sedition? I recall really applauding the government in 2022 when it said it would reconsider sedition, and now to see it back with wider powers, and now having local police with limited training, with stretched resources, at the end of the day, in a democracy where people can protest, also consider terrorism offenses. I think this sort of pushes more into the continuing colonial legacy as opposed to breaking a colonial legacy.
This was, I feel like, a very good roundup of what we are going to discuss over this video. But before going to the new criminal laws, I'd like us to talk a little bit about the old laws, just how the criminal law has interacted with businesses in the past. Tell us a little bit about that.
That's a great question, Apoorva. And I think the criminal law has generally interacted rather poorly. And there are 2 or 3 facets to this. And look, I don't think any one of us here would not want to see somebody who's committed a crime punished. So I think I'd start with that caveat. But it is the responsibility of the state to do so with due process and with fairness. There have been 2 significant challenges. I think first is the over-criminalization of our bureaucratic response in terms of legislative drafting to ensure compliance has somehow never gone to fines, which is generally the norm.
Right.
In other jurisdictions or other common law jurisdictions, it has always been of having the brute force of criminal law into compliance. And I think that is a challenge. It's a challenge for two sub-reasons. Number one, the state has no ability to prosecute, because down to an apprenticeship act or something which is dealing with labor law compliance, you have a criminal law provision. It doesn't have the deterrent effect because the state can't prosecute, and then we burden the state so it can't really deal with actual issues that impact citizens. So I think the first business interaction is to just see random criminalization in random legislations that ordinarily have no purpose having a penal provision. In fact, you would recall there was the uproar of the corporate social responsibility provision in the Companies Act that if you don't spend the money, you may have a penal provision. You could have a fine-based provision, you could have a punitive provision, but to have a penal provision that entails imprisonment is challenging. And why have imprisonment on the books that you cannot truly enforce? It's a moral, philosophical, constitutional, and governance question that kicks in. So that's one part of it. The second part of it at a high level, Apoorva, is that the procedural gaps that we have and the way the substantive law was actioned is that there have always been knee-jerk reactions to prosecution. Several of those knee-jerk reactions stem either from a lack of understanding or because the state is unable to act in another role is to again use the criminal law. And I think the length of time, length of proceedings, the harassment that businesses have faced in the process of criminal proceedings, responding, having to travel great distances. One of our largest banks are seated in Mumbai, but there'll be a person who has a deposit issue and is able to arm twist and get an FIR registered on an obscure provision in a remote village and then make this happen and then sort of have senior leadership summoned, breaking all principles of how an organization actually runs, how there is delegated management, how there's professional management, and directly have the CEO and board of directors summoned to have scenarios where if a check bounces, all directors, including independent directors, are being dragged into criminal prosecution. I think that is the part of the criminal justice system which goes hand in hand with ease of doing business, and we have a fairly poor track record on that. And I don't think that track record is due to lack of, I don't think it's any government's desire, but it is such a large, there's a need for such overwhelming structural reform, such deep training of our police forces, of our prosecution services, to be able to prevent such things from happening, where it would take a really long time. So I think these are two areas where businesses have truly struggled. And the impact of this has been that where we've genuinely had the need to prosecute, whether it's in the allocation of natural resources, whether it's been the great bank frauds or securities law frauds, the state, the prosecution authorities and the police authorities don't have the bandwidth to file detailed FIRs, to prepare detailed charge sheets, to fight trials, and as a result, those cases go scot-free. And when you sum all these three things up and you look at it from a business that does want to do the right thing, that may make an honest commercial error, I'm not talking about a criminal law intent, mens rea sort of posture, is the whole element of the process becomes the punishment. Today, we've created a structure, whether it's an economic offense or a business crime, that we celebrate arrests, we then celebrate attachment of assets, and we forget about it because the trial's never going to happen. And the trials happen much, much later, and with fairly straggling statistics in terms of the results, but you have lives destroyed for significant periods of time, and that's a big challenge for businesses to deal with.
Right. Sherbir, you talk about an overwhelming structural reform that was necessary, and you talk about a poor track record when it comes to interaction of businesses with the criminal law. Now, do these three laws even make a nick in that? Do they bring in that structural reform, even if not overwhelming? And I'd like you to answer this first in the light of the BNS. Tell me, how have the corporate offences changed, and do they in any way address the concerns that businesses have been raising?
So, Apoorva, the short answer to as far as the BNS is concerned, is that when you talk about typical corporate offences, you talk about cheating, which is which was one of the most celebrated sections of the past of our old Indian Penal Code.
400 BC.
400 BC. It's shown up in songs. It's something that folks know about and can relate to. So you have cheating, which sort of deals with a wide spectrum of fraud issues. You have criminal breach of trust, where there is somebody who's been entrusted with a property or a responsibility and has not discharged it. You have forgery, and then some allied offenses which go hand in hand, provision of false evidence, malicious prosecution. Now, when you look at these core offenses, not much has changed. I think on cheating, they've done a good job of bringing everything together.
Okay.
It's all come under one section, as opposed to previously being under several sections. For simpliciter cheating, and also for cheating where there is knowledge of wrongful loss, they've enhanced the punishments, but nothing on substantive text. So reorganization, bringing several sections into one section, but not in terms of the text hasn't changed very much.
Okay.
The ingredients of the offense largely stay the same. Criminal breach of trust, again, enhancement of punishment. A very interesting provision that even earlier, criminal breach of trust was reportable. It still is an offense that you're required to report to the police, but now you have the exception of saying that if there are good grounds not to report, which is sort of strange and neither here nor there. So we'll see where it goes. Forgery, no real change. Falsification of accounts, false evidence, no real change. But one of the interesting new elements that we do see come in, and I think one is for sort of industrial units. I think there's the death by negligence provision,
Okay.
which brings in mandatory imprisonment for a period of 2 to 5 years, where there has been death by negligence, which I do foresee being being used in the context of factories where unfortunate industrial accidents could take place, because that's generally been the knee jerk. I think if you look at this recent incident of this very unfortunate incident of the drowning in the UPSC coaching centers, and seeing the manner in which somebody who was driving has been brought in, it's usually this knee jerk reaction is what everybody's problem with the criminal justice system, and that doesn't get solved. But I think most interesting is the introduction of the organized crime into an organized crime offense into the BNS. Previously, Apoorva, as you know, organized crime was state-specific statute. Maharashtra had one, Gujarat had one, Andhra Pradesh had one. So they brought it in. They've introduced a concept of economic offenses and brought in the element to envisage multi-level marketing, fraud, or specific fraud to sort of defraud financial institutions. They brought in a concept of continuing criminal activity for a period of more than 3 years. They've also brought in the concept of a crime syndicate, which is 2 persons or more. I think this will be a very interesting posture to watch in terms of how it applies to how businesses are going to interact with this provision.
Right.
Again, the point I am trying to make is not that we don't need these provisions. The point I am trying to make is, what are our safeguards to deal with the application of these provisions in the precedent we have seen over the last, I'd say, 30 years.
And what are these safeguards? Do we have them in place
I
right
don't
now?
think we do. I don't think we do, because the rest of the structure hasn't moved and changed. Our
Right.
law enforcement isn't changing. We are not changing norms of custodial interrogation. We are not making the preliminary inquiry more serious. And if when we switch to the sort of the BNSS,
We will get to it.
I think we'll see how some of those procedural safeguards don't interact as well as they should.
Okay, so let's get to that now. You've been highlighting the concerns of businesses. You spoke about the propensity of arrests. You spoke about how we have such a huge number of under trials who are in jail. We spoke about administration of justice generally. So tell us what has changed procedurally.
Apoorva, the biggest lacuna in our criminal justice system is the struggle. One of the key issues is the struggle in how our police stations are organized, coupled with how the prosecutor interacts with them. In an ideal world, the prosecutor is supposed to be an independent check and balance to police action and inaction.
Right.
Now that doesn't happen. Effectively, till the trial commences, even at the investigation stage, the matter gets committed to court, but effectively till the trial commences, the law enforcement body or the police is the be-all and end-all.
Right.
They make their decisions for arrest. They make their decisions for search and seizure. They make their decisions of what's going to go into the charge sheet. There is legal vetting, but it's not to say this should not go in for this reason. Now that's, ideally they still have the power to do so, but in practice and precedent, we are not seeing that. Now, in terms of the key procedural changes that have come in, I think there's a lot. The ones that I struggle most with is the position of custody. Now, custody applies whether to a business crime or it applies to a blood crime. And I think first and foremost, I think we'd be one of the few countries in the world that would have a provision that previously allowed for 14 days of police custody. The reliance, our jurisprudence, we've had a rich history of some good jurisprudence and some pretty terrible jurisprudence. But our jurisprudence on custodial interrogation and the need for it belies the very essence of liberty. And now custodial interrogation is 15 days, spread over a large spectrum of time,
Right.
with a significant scope for abuse. So in certain classes of offenses, you can do it multiple times in a 40 to 60 day window, and for another class of offenses, it's in a 60 to 90 day window.
Can you tell our viewers what the difference is between the custody in the new law and in the older law?
Sure. So you have 2 types of custody. There's police custody and there's judicial custody.
Right.
Police custody is when you're before a law enforcement body. Police being, it could be the Central Bureau of Investigation or the Enforcement Directorate, or like the Enforcement Directorate likes to believe it's not the police. But so when they hold you in their custody, which is typically on their premises, that is police custody.
And they have access to you for
They
interrogation
have access
the entire
for
time, for
interrogation,
questioning.
precisely, and their objective is to sort of enhance the investigation.
Right.
Now that typically happens after the registration of an FIR. Then comes the element of judicial custody, which is you get produced before a magistrate, which you have to be done within 24 hours, and the judge can then decide whether you need to be in police custody or you can be in judicial custody. In judicial custody, you're within the jurisdiction of the court. The court is responsible for your custody,
So
and
you're
has
in
more
a
safeguards. You go to a prison,
central prison, or a state
precisely.
prison, right?
Precisely. You go to a central or a state prison, versus in police custody, you stay within the premises and the confines of that particular police station. So earlier, police custody was maximum granted for a period of 14 days, after which you mandatorily moved to judicial custody if custody was relevant, if you were a flight risk, if there was a chance of evidence tampering, or there was further investigation needed for which custody is there. The breakdown of that system became that we just inevitably, like we had great jurisprudence on bail, which always said that bail is the rule and jail is the exception. That collapsed on its face, and we effectively became a place where custody just continued, and you didn't. And as lawyers and as accused, I'm not talking about the gravity of the offense. Gravity of the offense is divorced in a lot of instances. In the context of bail, has to be seen within the lens of what would you do? Can you recommit the offense? Will you tamper with evidence? Are you a flight risk? Are you likely to do things that would impede the investigation? But we don't look at that. It's become a mechanical process. In my career, I have never seen an accused being released in remand, which is the first time you're produced after 24 hours when you're produced. And the magistrate is empowered to do so, but I have never seen one. And I posed an academic question to several leading criminal lawyers who we engage with. And I think over the last 25 years, and it's not government specific, there's a lot of move towards making it a particular political party's posture. It's been the same.
Right.
Now, when you take that import to the new laws, the 15-day custody period, I think the Home Minister gave a clarification here, can be taken multiple times for a total period of 15 days, but within a 40 to 60-day window. And I think the scope for certain classes of offences and for more serious classes of offences is a 60 to 90-day window. I think the scope for abuse is knowing our precedent is going to be somebody's going to go to police custody, go to judicial custody, come back to police custody, go. And effectively you're looking at, given our magistrates' poor track records of upholding liberty, I think this is a death knell for
Correct.
a 40-day, 60-day or a 90-day period in custody.
Correct me if I'm wrong, is it also tougher to get bail while you have police custody days pending?
It should not be.
But in practice?
In practice it is. In practice it is, I think. You have all these theories moving around, and it sort of pains my heart to see this happen. And especially in cases like the example I gave you where businesses interact, where there is an unfortunate incident on a factory premise, or there is, sometimes it could be a poor advertisement, or I dealt with a matter where a global payments company, a child used his grandfather's credit card to to buy some coins or tokens through a game platform, which was a parental control issue with the App Store and this. And instead of addressing it in a manner that in a constructive manner, I had senior leadership of this global payment system arrested and in custody for several days. And the gentleman in custody was, didn't know what hit him.
Right.
Was picked up from Bombay and taken to Hyderabad. Has studied in some of the finest colleges in our country, and then only to get bail and have a bail order which says that the police had no grounds. But this person has been in custody, and what are we going to give compensation? I remember one of the first cases we read about where somebody was acquitted and was in jail for several years, got compensation of a princely sum of 50,000 rupees for losing several years of their life. So, to your point of Does it become harder? It has. I think bail in general has become harder. We are today as criminal lawyers fighting bails like we're supposed to fight trials, because our trials don't start, and we are all, and the police is hoping that we will create a defense and then they'll write the charge sheet around our defense. The balance of power in a adversarial system is increasingly broken when it comes down to it.
Right. So we've spoken about custody. Now, what are the other procedural changes that these laws bring in?
I think, since I've given my views on liberty, which are fairly strong,
Right.
I think, so there's a very interesting provision that requires that search and seizure now has to be videographed and have video and audio recording. Heavily welcome this. I think the CBI had started with this process. It was part of their manual. And it really helped the CBI become a professional force. I think the CBI manual single-handedly, the efforts that were undertaken to write it really helped them become a professional force. And seeing that here really is heartwarming.
Right.
Again, we are going to have an administration of justice challenge on what are they going to record. What are these devices? They say that it should be preferably on a cell phone. Whose cell phone? How do we prevent that from getting altered? It is virtually, if somebody acts in a high-handed manner, what are going to be the camera angles to that?
Right.
Of course, you don't want that in a substantive law. There can be guidelines, but those guidelines should have come at the time of implementation. That cannot be an afterthought. So that is a provision I'm genuinely very happy to see. I'm also happy to see that there should be videography when it also comes to interrogation. But again, I think missed opportunity there, I said, to have legal counsel present. Again, the question of whose devices. A challenging provision which businesses have struggled with. And by businesses, I'm not talking about those in the throes of criminal offenses. I'm talking about allied banks, non-banking financial institutions, asset reconstruction companies, is forfeiture of assets.
Right.
The forfeiture regime under the Prevention of Money Laundering Act has faced multiple challenges in terms of whether sufficient reasons to believe are there, how the money laundering statute has interacted with the insolvency statute. But that was a special power. Now, for any criminal offense under the BNS, forfeiture of property is possible.
Okay.
So now you have even minor criminal offenses. There can be forfeiture that takes place, and the process of forfeiture, we weren't able to really fix this process of forfeiture with a specific tribunal who looked into this particular the affairs of these
Under
forfeitures.
PMLA.
And now we're going to our existing system, which is already burdened, going to deal with multiple interpretation challenges, is also going to be dealing with this. So I find that to be something that businesses are going to struggle with, and especially banks and NBFCs and ARCs are going to really struggle with. I think we are making the enforcement of a contract much harder.
So before you move on to the next point, I'm sorry for cutting you off,
not
but
at
when
all.
we talk about technology, do we have the bandwidth actually to implement those provisions on the ground? If you imagine a police station, do you think that the police officers there have the technical know-how or the bandwidth to actually adhere to all these provisions enough for it to pass the muster of the trial court when the trial goes on?
I don't think so. And here I'd like to say that my heart also goes out to our policemen.
Right.
For what all tasks from law and order to investigations a local police station has. The hours our policemen keep are inhuman. For them to fill out an FIR form, for them to record evidence, for them to record statements that can be signed, all exceptionally challenging. So, and we haven't brought in the technological infrastructure to deal with those challenges.
Right.
Whether it's transcription services, whether it is what cameras, what type of audio-visual recording devices are we going to use? How are we going to train them in using those? That's all very important. You know, a couple of days back, I saw that the Punjab police was undertaking several search and cordon and search operations, very strange word used in the context of their drug drive, and they were taking pictures of people's bedrooms. At that stage, it's a matter of investigation. Then taking those pictures and posting them on Twitter is a complete invasion of privacy. It's a complete invasion of everything we stand for.
Right.
So it's not just that we're going to need the technological infrastructure, we're also going to need the training infrastructure to be able to explain how the technology that they use needs to interact with first universal principles of our constitutional rights.
So a lot of sensitization
There
also
is.
perhaps with regard to the right of privacy of even the accused that they're dealing with, right?
Absolutely. Posting pictures, disclosing, the disclosing information about their residences and other things. There is, and not through a judicial process, but through social media. I think there's a lot of training to happen, and I think that's to just quickly segue to the broader point.
Right.
I think a critical element that, again, a lost opportunity was fair. We got new criminal laws, and that's, whether there was a political objective or otherwise, we can debate that separately. But again, when it came to implementation, first the passing of these criminal laws in terms of how limited the parliamentary debate was on it, the limited reference to the Law Commission or no reference to the Law Commission.
Right.
And then coming to the implementation. I said this required a Herculean effort of training, of getting these technology. There's no point in saying that you can serve summons electronically, and if it's going to come from from a police officer's personal cell phone on WhatsApp, and there's going to be no mechanism of keeping an audit trail of the same. Where is the audit trail going to be filed? Are we going to file screenshots in court with the ability that screenshots can be manipulated? So there was a lot that had to be done, and not a lot that would take years. It required a proper action plan. It required the implementation of that action plan, and could have been achieved, and could have been achieved if it could have been achieved in a 6 to 8 month framework, which is pretty much the time that was there. But that's not happened.
Right.
And now we are entering a period of chaos.
Yeah, one last question before we wrap up, Sherbir. Now we've spoken about, there's been a lot of criticism of these laws, of course. You've spoken about a few missed opportunities, quite a few of them, of course. Are there any positives that you see in these new laws?
Absolutely, Apoorva, there are definite positives. I think the handling of introduction of electronic evidence, both in terms of definition, so that we don't have to rely on precedent to read electronic evidence into the investigative record. I think that's a definite win. I think the second part is the audio video videography regarding search and seizure as well as interrogations, which I think is a definite win for civil liberties. Rough ends around how it needs to be implemented, but definitely a very, very good move. And I think the third that I would put is the prescription of certain timelines.
Right, okay.
Both for the preliminary inquiry, both also of coming back to a victim and a complainant and giving them a right to ask for the status of the investigation. So whether it's a company complaining about how they've been defrauded or a bank complaining, they now have a right to get that information back. Earlier, while they were a complainant, their right in trial, their right to have access to information to initiate other proceedings was challenging. So I think that's a good right to bring in as far as the victim or the complainant is concerned to get an answer back.
Right.
I would put those three, these three, due to paucity of time. I think there are a couple of others. I think we should all move towards the step of saying that this is our new law. We've got to embrace it. The state has actions to take. We all must strive towards improving them and creating a body of work and guidelines and principles. But the reform of the criminal justice system must not start and end with these new laws.
Right. Okay, on that note, we've reached the end of this video. Of course, as Sherbir said, there was a huge need for a big reform of our criminal justice system, so to say, the administration of justice as well. But there are quite a few missed opportunities in these three laws. Thank you so much for joining us for this, Sherbir. And thank you so much for all our viewers for watching this. Do let us know in the comment section what you think about this video. Thank you for watching.
Thank you.